The next case that we will hear this morning is the argument in Page versus The Big Show. It is case number 21CA011714. Attorney Miller, as you can see, Judge Callahan is joining us, as well as Judge Hensel. Judge Callahan will be keeping time on this, so please, we want to thank her for doing that. Thank you, Judge Callahan. Of course, the judges on the panel have read the briefs, and we are prepared to proceed. If you are, and each side will have 15 minutes to present your argument, appellant may reserve up to 5 minutes. All right, with that, we'll hear from Attorney Bremke.
Yes, Your Honor. Giovanna Bremke on behalf of The Big Show. I would reserve 5 minutes of my time for rebuttal. At the risk of being repetitive, this case is somewhat similar to the last argument, but I understand Attorney Miller was not in on that argument. So I will make some of the same arguments. There are some distinctions in this case. But again, this case presents a small claims case that deals with a catering contract in the middle of a global pandemic. There's 3 assignments of error. The first is that the sole reason for rescinding the contract is based on receipts that the court alleges did not comply with the Ohio Sales Consumer Practices Act under the Ohio Administrative Code 109-4307. These receipts were never admitted. And in fact, this case does have a distinction between the previous case. In this case, the receipts were not presented at all. They were not discussed at all. In the prior case, there was a stipulation as to payment, but in this case, neither party presented any receipts. And if you look at the footnote on the first page of the judgment entry, it says the court can only conclude that there are no receipts for payments made that would satisfy the requirements, and that is because in what that's footnoting to is the sentence that said there were no receipts for these payments submitted into evidence by either party. Of course, we know that burden falls on the plaintiff. Again, there were no receipts. There were no, again, in the prior case, there was email confirmations. There was nothing of that nature in this case, nothing for the court to rely on whatsoever in determining that the receipts didn't comply with the Ohio Administrative Code, which again, this is a little bit even mind-blowing that the court would conclude that because there were no receipts, it would have to conclude that they didn't comply. Because again, this is not that shifts the burden to the defendant to prove any possible argument that wasn't even raised at the trial court in the plaintiff's complaint. It wasn't raised at the hearing. And so there were no, it would be as if the defendants in any case, any civil case would have to potentially defend against any potential defense and for things that weren't even admitted at the trial. This case also has another distinction in the manifest weight of the evidence in that this wedding was to occur in October of 2020. And these individuals or this plaintiff appellee canceled in June of 2020. So at the time of the cancellation, there were some restrictions on weddings, but they could take place. And by October of 2020, I believe there were no restrictions, maybe some suggestions by the governor, but no restrictions. So in this case, the wedding could have gone forward in October, it was October 3rd of 2020. It could have gone forward with no restrictions as originally intended under the contract. However, Ms. Page did cancel this contract before in June, well before the wedding was to take place. So again, that's sort of a distinction between this case and the prior case. Again, the court relies a second assignment of error. There is not a distinction between the prior case. There's a rescission of the contract. The rescission is equitable relief, which is not permitted under 1952.02. I cite case law that supports the idea that it's equitable relief is not permitted in a small claims court, and therefore the court didn't have jurisdiction to rescind the contract. Again, I think the appellee argues that although the court says it's a rescission, really it's intended for that there's another the court didn't really mean that, but the court explicitly, this is the last page of the entry, explicitly says that the trial court, the trial court says that the plaintiffs are entitled to rescission of the contract and a return of the full amount. So it wasn't as if there was any dispute there. The court explicitly said rescission. And lastly, again, the court shifts the burden to the big show to question the witnesses in this case. And in doing that, again, for the second time, shifts the burden to the big show instead of having the burden on the small claims plaintiff at the matter. I would reserve the rest of my time.
All right, thank you, Attorney Bremke. Attorney Miller, you may proceed.
Thank you, Your Honors, and may it please the court. Attorney Justin Miller here for appellee plaintiff Laneshia Page. COVID messed up a lot of things. COVID messed up a lot of businesses, a lot of plans, a lot of lives. But the one issue that has to be addressed with this court is that COVID was unknown. COVID was still unknown at the beginning of this year. So there were a lot of changes and concerns and issues that were in a lot of people's mind, including my clients, including the appellants, during this entire time. And I think it's important to point out that context because there were emails that were presented to the trial court regarding this back and forth about, well, what are we going to do? Can we have this wedding? Are we able to have this wedding? The appellant responding, well, we're not sure, and we do have restrictions, but there's a lot of people that are canceling and we're not rebooking. We're not doing this. We're not doing that. From the appellant, putting doubt in my client's mind as to whether or not this was going to go forward. Was this a potentially preemptive issue? Yes. Because she and her fiance needed time. They needed time to find another venue potentially, or save up for another venue. But the timing should only be considered really for one specific issue. And it's the amount of time between the cancellation and the actual event, coupled with the fact that my client had already paid the fee in full. And I think that's an important distinction here as we get along. The appellant raises three issues. One, that the manifest weight of the evidence didn't support the court's ruling. This is a small claims case filed pro se by a non-lawyer on a standard court form where you fill in the blank. There's little room, if any, to have any detailed complaints, as most attorneys would probably provide in a breach of contract. It's simply, I paid this to get this. I canceled it. I want my money back. Short, simple, to the point. no specific causes of action or claims, no breach of contract, no unjust enrichment, no fraud, no breach of warranty, no specified claim. So the court had the hearing. Both parties stipulated that my client paid the amount in full. Both parties stipulated when the event was supposed to happen. Both parties stipulated as to when the fees were paid. Both clients had stipulated to when the cancellation was requested. All those statements, all those facts, which normally would be the initial burden of the plaintiff to bring forward, that that they entered into a contract, stipulated, that she paid the deposit, stipulated, that there was concern about performance, stipulated, via the emails that were provided, that my client had requested a refund, stipulated, that a refund had not been provided, stipulated. All those elements, that entire chain was stipulated to. Therefore, my client's burden had been met by agreement. The next logical step was for the defendant to prove their defense. That defense was the amount paid was non-refundable. And the only statement that pertained to it was a notation in the contract that specifically said that additional funds would not be refunded. Additional. No definition as to what additional meant. No context, nothing, no definitions. And that was what appellant relied on. That was their basis for the relying. So the court didn't erroneously shift the burden. The court just moved along the logical process. Plaintiff's burden was met through these stipulations, and then the defendant had the ability to bring its burden. Plaintiff testified, had a witness, and an ability to rebut defendant's burden. So there was no burden shifting. There was no error in the logical transition. And the fact that appellant's defense counsel, John Greco, cross-examined plaintiff, again, was not evidence in and of itself that there was burden switching, because the stipulations were already there. And the defendant had
Is there a problem, Mr. Miller, is there a problem with the court's entry in that it didn't find a breach of contract? It didn't award damages for a breach of contract. Rather, it specifically mentioned rescission, which is an equitable remedy and beyond the scope of a small claims court jurisdiction.
I was about to get to that, Your Honor. Thank you. The jurisdiction pertains to the manner in which the claim is brought before the court. And 1925.02 specifically states what those jurisdictional amounts are. Libel, slander, malicious prosecution, abusive process, anything regarding political subdivision, recover punitive exemplary damages. The complaint itself asked for monetary damages under the jurisdictional amount of $6,000. That met the jurisdictional issue. This was the court making a decision as to the type of relief that could have been granted. So the type of relief would have been up to judicial discretion, which I do not believe was abused here. But the jurisdiction was met because it was simply a monetary damage request. So in long answer to a short question, no, I don't believe the court's decision was an error because of the type of relief that was issued.
I guess what's going through my mind now is whether the court, a small claim court, can properly grant equitable relief, or are you saying it did not grant? I mean, rescission is equitable, right? It's an equitable remedy.
It was not. It was not formally requested, though. It was a decision that the court made. It could have been the same because the contract was impossible to perform via COVID. Impossibility would have been defense that would have resulted in rescission of the contract. It could have been unjust enrichment because the defendant appellant was paid in full, and there was really no guarantee that they were going to be able to follow through with the venue at the time in question. And given the refund, it would have been unjust for them to maintain or keep the full refund when nothing had been done in preparation for the event. So in terms of this, equitable relief, there are many paths to that. Because the ultimate request was that she get the money back. And realistically, the true only way to accomplish that would have been some ruling that the contract was void or impossible or otherwise unable to be performed, and therefore should have been rescinded in the first place. So I think that the issue of the court issuing equitable relief is kind of a byproduct of the nature of the contract case. But the initial claim, the initial basis for it on which the jurisdiction is determined was that of monetary relief under the limit of $6,000.
Okay, thank you.
But getting to the issues of the receipts, there were discussions during the course of the hearing about what was paid, when it was paid, how it was paid. Stipulation that the full amount was paid, but under which whether or not my client received receipts, there was testimony to that. There's testimony to the fact that she didn't get receipts. She wasn't provided any indication as to proof or confirmation that she paid this, this was due, this was non-refundable, those kinds of things. And then that ties back to the sole basis for the defense of the non-refundability, which is in the contract in of itself without context or definitions to what the additional deposits would have pertained to. My client didn't pay anything above and beyond what she was obligated to do so. She paid everything in a timely manner, but the issue of the receipts is something that is tangentially related to appellant's argument that the money my client paid is non-refundable. And so we would argue that, and the court did cite a similar case. The court did cite a case along those lines where a wedding venue didn't issue a refund as justification for its decision. Now, appellant used the case as a basis for the issue of the burden shifting, and I don't think that's necessarily correct. I do believe that case was used primarily to as a comparable position that the court should have ruled on. The court was using precedent.
I
to
think
make the
the
decision.
distinction drawn by opposing counsel was that was a case that was transferred to the common pleas court, and therefore rescission was clearly within that court's ability to grant. Am I wrong on that?
No, you're not. The common pleas court obviously has that ability to do it, but it doesn't necessarily answer the question of whether or not it would have been improper for the small claims court to take it because it was transferred for another reason.
Mr. Miller, you have 1 minute left.
Thank you, Your Honor. But with that statement, I'm done with my argument and willing to entertain any other questions the court may have for the remaining time.
All right. Any questions, Judge Hensel or Judge Callahan? All right. Seeing none, we'll hear from Attorney Brunke.
Thank you, court.
Yes, Your Honor, it's just in reply to some of the arguments that the appellee makes, and I think also the prior appellee as well. Both of them keep saying these are pro se litigants. What we know and what this court was very familiar with is that pro se litigants are held to the same standard as attorneys. Nobody restricted these individuals from getting counsel. There was never a request for continuance to get counsel. They were pro se by their own choice and should be held to the same standard as my client. They don't get a pass for being pro se. Same thing goes with the stipulations. In both cases, there are stipulations. And this court has sort of repeatedly addressed that issue. And in fact, it's something that I know that the judges, when they speak at continuing education classes, warn trial counsel. If you stipulate, that puts, it's something that is difficult to review on appeal because there's a stipulation. And in both of these cases, there were stipulations as to the amounts paid. It was improper for the court to consider any sort of receipts. They weren't admitted. They were, particularly in this case, they weren't even presented at all. And there would be no way for the court to conclude that the receipts violated the Consumer Sales Practices Act, which, again, I believe the rescission was based on because of a violation of the Consumer Sales Practices Act. But you don't even get there unless you address the first assignment of error, which is the receipts shouldn't have been considered by the court. And in fact, I would say both cases, there was no receipts admitted. The first case, there was email confirmations, but in this case, there was nothing. And therefore, there was no right to rescission. We would ask that you reverse the judgment. Thank you.
All right. Thank you both for your arguments today, and thank you for appearing on Zoom as well. The court will take the matter under advisement and render a decision in due course. Of course, you each will receive a copy of that decision, and our decisions are also posted on the Supreme Court's website. We want to thank you both for participating today and wish you both a good day. Thank you.